Okay, we're back on the record.
Mr. Norton, go ahead.
Mr. Chairman, unless someone who is on the opposite side of the position that I'm taking wants to make the motion, I'm happy to provide the verbiage if someone wants to make it a motion.
I just made a motion. My motion was to find, in the finding of the fact that he that he did violate the Brokers Act, or that he answered on his questionnaire for license that whether he had ever, what was he aware that anything been filed against him, whatever the proper verbiage is, up to and forward. Did he have knowledge of that? Yes, he had knowledge. He had knowledge that there was a case against him
With the Tennessee Securities Division.
on the Tennessee Securities. He had knowledge of that when he filled out his application.
I'll second that.
We have a motion and a second that one of the findings of fact was in fact true, that the Adrian Bond in this matter had knowledge that he had this matter brought before him from the Tennessee Securities Division. And we have a second by Commissioner DeSharp. Discussion on this motion.
Well, I'll offer a little bit of discussion simply to, and I don't want to prolong this. As I've stated, you all are probably aware of my position with regards to that motion. And I take that position not just because I haven't been convinced that he did in fact have knowledge. I take that position because, one, I wasn't convinced, and two, I take very seriously taking the actions that would result from that, which may or may not prevent an individual from continuing to create a livelihood for the families. This is a profession that I love, and I know that there are times when we need to police, and I agree that this is one of those times. I'm just not convinced that we are at a point where we should be making assumptions that lead to actions that could be as dramatic as what we would ordinarily take under the circumstances.
But if he can't get a license for securities again, then that creates a problem for a real estate license.
Not necessarily. He's been in business since 2005. There's not been a complaint.
But according to our law, that's a problem.
I didn't say it wasn't a problem. I'm saying there has not been a complaint. I've not seen where he's done harm to the public.
In real estate.
In real estate.
Mr. Northern?
Yes, Commissioner Alexander.
I think that there could be a complaint opened immediately against him or his company.
I follow you and I agree with that, but that's not before us at this point.
I realize that, but I'm going to rest right there. The only thing that I would, and I don't know whether you could do this or not, I'm not for giving this man a free walk. But I would certainly be willing to, and we've gone to this expense, and I don't know how you handle this, but to let this clarified about, and go back and let him work out with this other board, and whether it's in what position they're going to take, because you've opened up something that for the securities that somebody's going to have to address if that's a false signature. Now, if you want to delay this, or if you want to finish it, it doesn't matter to me. But I will not vote and it'll be the majority, so it wouldn't really matter, but I'm telling you that I'm not gonna vote to give him a free walk.
The motion on the floor is that he had knowledge that 2 and 4, when he answered no, that he was telling something that wasn't true. I mean, you've heard all the testimony, the discussion that we've had, but we're going to vote. All in favor say, and the motion is that he in fact was aware that he had his license with the insurance security, the securities, Tennessee Securities, that he had had issues with that, and he had had that consent order was out there, hanging out there. That's the motion on the floor, and a second.
My question is, would that also include that his license was revoked?
They're not revoked.
You mean from securities or from
From
traffic?
securities.
Was that part of your motion, Commissioner Alexander?
Well, that's why I'm asking. I'm asking for a
As far as the
clarification.
securities thing, other than the fact that it's on the website, that there was a consent order and that he signed it, that this commission, that our staff relied on to file this complaint. Other than that, I don't have any, I'm not in, I think he's got an issue that he needs to address with that board to clarify that, to do that. But he knew it was there. He knew it was there, and it didn't say that you've been convicted of it, but have you been accused of it? Is that not right? Is that what the application says on to obtain a license?
Have you ever had a complaint filed against you with any regulatory agency or with any court?
Yes, there was a complaint filed.
That's the motion. That in fact, this gentleman knew when he filled out that application, and he said no. All in favor say aye or yes.
Aye.
All opposed say no.
No.
That means
2 to 2,
you.
and you vote. Break the tie.
I vote yes.
So the motion carries.
The motion carries 3 to 2. And does anybody else want to enter any findings of fact into the record in this matter?
Shall we move to the conclusions of law?
Well, one more I mean, if we're gonna look at this document,
Which document?
the document that was
My
posted.
motion had nothing to do with that document.
I know, I'm thinking of another finding of fact. I think it's a finding of fact that this document was posted on the internet or seen on the internet, I would assume, as of the day 4/10/12. I mean, I don't know if it was on the internet before that. It may have been. Well, I don't know. So that wouldn't be a finding of fact. But I think we need some sort of finding of fact where this document came from.
Well, it was faxed to the commission.
Maybe this document was faxed to the commission on a certain date?
It was.
I mean, that should be a finding of fact.
It was faxed to the commission. It was an anonymous complaint.
Okay, well, maybe,
Faxed to the commission.
well, maybe that should be a finding of fact that,
But, and then you get into the, whoever sent this in,
okay,
probably
Move it along, I'll
went
make a motion.
to the
Commissioner
website.
Northern, make a motion.
okay.
I move that the Tennessee Real Estate Commission received information that would indicate that Mr. Bond had had a license, had had a complaint filed and a consent order filed by the Securities Commission, and that information was received anonymously via fax, and the commission acted in earnest and followed up to verify the authenticity of the document, which led to the filing of the consent order that was it consent order or agreed citation that was sent to Mr. Vaughn? Agreed citation.
It was a complaint.
Complaint, that's right. I'm way ahead of where we should be, okay. Which led to the filing of the complaint. And I will further state that the document in question did in fact raise some question by members of the commission. Does that say what you wanted it to
I
say?
didn't hear.
Document in question what?
Did in fact raise some questions by the commissioners.
Yeah, the yeah.
You've heard the motion. Do I hear a second? We
I'll
have
second
Commissioner
that.
DeShaw seconds the motion that Commissioner Northern made. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Now, we have, Commissioner Northern, Commissioner Northern, you have brought to, right, the finding of fact earlier was the issue concerning right, I know we did this, the 3-month period between the time he received it, he had 10 days to respond, and it was like 3 months later. You've already, that was already a finding of fact.
Right.
Okay. Does anybody have any other findings of fact in this matter? Not, then we need to move on to conclusions of law.
Mr. Chairman, I make the motion that the respondent's acts and conduct as described in the foregoing allegations of fact constitute a violation of Tennessee Code annotated 62-13-312B, wherein the commission shall have the power to refuse a license for cause or to suspend or revoke the license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of 1, making any substantial and willful misrepresentation, and may further be assessed the cost of investigatory and hearing costs pursuant to Tennessee Code 56-1-311 and Tennessee Comps and Regs 0780-5-11-.01.
I second.
I have a motion and a second as to the conclusions of law. If there's violations, any discussion?
And if I misstated any of the numbers, just fix it in the...
No discussion, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously.
Mr. Chairman, as conclusion of law, I move that the respondent's acts and conduct as described in the foregoing allegations of fact constitute a violation of Tennessee Code annotated 62-13-312B, wherein the commission shall have the power to refuse a license for cause or to suspend a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of 14, violating any provision of this chapter, any rule duly promulgated and adopted under this chapter, or the terms of any lawful order entered by this commission. Such a violation constitutes grounds for possible disciplinary action and civil penalties, and the assessment of investigatory and hearing costs pursuant to Tennessee Code 56-1-311 and Tennessee Comps and Regs 0780-5-11-.01.
I second.
Heard the motion and a second under the conclusions of law. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Chairman, under conclusions of the law, I move that respondent's action conduct as described in the foregoing allegations of facts constitute a violation of Tennessee Code annotated 62-13-312B, wherein the commission shall have the power to refuse a license for cause or to suspend a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of 20, any conduct, whether of the same or different character from that herein before specified, which constitutes improper, fraudulent, and dishonest dealings.
Second.
And the motion by Commissioner Northern and seconded by Commissioner DeShaw. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries unanimously.
Mr. Chairman, as a conclusion of law, I move that respondent's action conduct as described above constitute a violation of Tennessee Code annotated 62-13-313A2, which provides in pertinent part that the accused applicant or licensee shall, within 10 days, file with the Commission the applicant's or licensee's answer to the complaint, a copy of which shall be transmitted to the complainant.
Second.
Motion by Commissioner Northern and second by Commissioner DeShara. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, I have no other conclusions of law to propose.
Okay. Do what?
He said there's no other.
Oh, I know other. I thought you said you had one other. I'm sorry. I misunderstood. Now, we have determined findings of fact in this matter, conclusions of the law and of our statutes. Now we need to decide upon what kind of action would be appropriate in this matter against Mr. Bond.
I have a question, Mr. Chairman, before we get into this, and what is the status? He never was issued a broker's license, is that correct? No, a broker's license was never issued?
No. He,
Okay, so we don't have to deal with being a broker's license?
no, he does not have a broker's license,
Does not have a broker's license.
just an affiliate.
He's an affiliate broker.
Correct.
He's passed his test.
Passed it, but he has not taken the broker's exam. All right. So where we go from here then is what we do
Penalty phase.
with his affiliate license. Is that right?
Right.
Okay. I have, Isaac, you got a recommendation?
He asked if Isaac does.
No, he asked if Isaac had a record.
Oh, yes, if I had a recommendation?
Yeah.
What would be
I'm sorry.
appropriate in this matter, based on the evidence and findings of facts and the conclusions of law? What do you feel
Well,
would
if
be?
we look at the manual, 62-13-312B1, office penalties ranging from 50 to 1,000. B14 is 1,000, and the other must be in the new rules of order, because I can't find it in the manual.
The new rules are here.
It is? And I don't have a manual, I don't have the book, so I can't. But I assume it's like the others as we amended them to be $1,000 each. It is?
They're on the iPad.
It's
You
on
have
the
the iPad, they're on the iPad.
Ms. Maxwell, would you save us the trouble and tell us if it's 1,000 each maximum?
Here it is, right here.
Is it this, let the record reflect that Ms. Maxwell is handing them their list of civil penalties?
Right.
Has it been shown to respondent?
Which one? 312B?
312B we got, 313 is, I believe it, 313, 311.
Sure, you may distribute it to Commissioner Northern.
Three, oh, one is 1,000. 13, 12
Got it?
is 1,000.
Okay. And 56-1, 311?
While y'all over figuring, I know we trying to determine the appropriate penalty, because all the times I've been on the commission, no two matters have ever been the same. They're all different.
While Commissioner DeChara is looking it up,
It's not in
I'll just go back.
May I,
and-
Your Honor, may I clarify for them, because they're not understanding? Your penalties are all under 62-13-312.
which is this right here.
Right. And so then
So
you
the
have,
maximum will be $1,000 on each count.
well, I don't know, that's what's in
Right
front of
here.
but that's where your penalties are.
I understand 50 to 100,000 is the range that the statute offers.
It depends on the violation under 312, and whether it's subsection 1, subsection 14, subsection 20.
One, 14, and 20, Robin?
Oh, I'm
Right, 1,
I'm
14,
giving
and-
suggestions.
And 20 is what the state has asked for.
Okay.
Yeah, for 114,
One is
14, 1 and 20 is what we
They
were.
they all maxed out at 1,000.
Yeah,
Okay, I was just clarifying where you look for that.
Okay.
14 is
They
from
vary
50 to
from 50 to 250 on the low side and 1,000 on the maximum. Does that give you your answer, Commissioner Alexander?
I have no, I'm not gonna make a motion.
I think Commissioner Alexander is deferring.
I'm deferring to
To
you
the
and
other
somebody
end of
else,
the
to other
table.
commissioners. I have no motion on this.
We got to determine what is appropriate based on the facts.
I would make a comment, Mr. Northern, that this gentleman has issues that he's gonna have to solve besides this. I personally, at this point, I think that he's probably has been awakened to the facts of life, and that you need to respond to actions that have been filed against you. I personally don't think we ought to take his affiliate broker's license. I think you ought to give him an opportunity to work in this profession if he so desires. And then he may have some other complaints that may come before this commission by some other actions that hadn't been filed that we hadn't discussed today. So my recommendation to whoever makes a motion as a commissioner on this commission, that his license not be revoked. That's simply a recommendation. If you can now put together something that the rest of the commission would be satisfied with.
I concur with your comments, Commissioner Alexander. I think Commissioner DeCharle was going to offer up
Can I make
post
another,
penalty.
can I make a very quick comment also? Those of us sitting around this table, Commissioner Northern,
You, the senior member, we're looking to you for some guidance and some leadership.
I feel like y'all are trying to convince me, but I'm not.
No, we're not trying to convince you, Commissioner, because we have already, we've found those facts. We're there now. It's where the penalty is.
What's
And
appropriate?
in no way would I want to put that burden on you, except I think that you're more compassionate towards this individual than we might be, and I'm trying to give him an opportunity to, because I see other problems coming down the road. I think he's going to have to, now with this, he's going to have to address this other complaint, and he's going to have a full time with that, in my opinion, and I'm just trying to, I'm trying to give him some leniency.
I understand.
Huh?
I understand. I appreciate it. And Commissioner DeCharle, did you want to offer the penalty, or do you want me to?
No,
propose?
because my issue is totally different. Mr. Bond, you're an extremely smart man. It's obvious to that. You keep letting your license expire, you go back, you get retested, we reissue them. You've got this other issue that I don't know if you signed it, I don't know if you didn't, but see, I guess I'm probably obviously not the most compassionate in this case, because I think your license needs to be suspended until you get your other matters taken care of. So, no, I'm probably not the one you want making the motion, because I'm not as compassionate about that.
Well, we have made, we have voted yes on the findings of facts that Mr. Bond was in violation of 3 counts of falsifying information on applications. As previously stated, the range was 50 to 1,000. I would make a motion that on each count, we impose a penalty of $500.
And court costs.
I'm not through.
Oh, excuse me. I'm sorry. I thought you were third. Go ahead. I apologize.
Well, I stop at that one because I think the next one will probably be a little bit more controversial, so.
If we're gonna do
Now,
them in stages here.
Okay.
But we can go ahead and add the cost if that's your desire,
Now-
Commissioner Alexander.
Now, for the record, you're saying that each one of these conclusions of law, a $500 fine for each one?
Correct. No, the first 3.
The first 3, which are,
Falsifying or misleading on the application.
okay, which would be a
There
total,
were three incidents of that.
so it'd be a total of $1,500, $500 each of those 3. Any discussion to it? And seconded, do we have a second?
Second.
We have a motion, Commissioner Northern, second by Commissioner.
Does that include the non-revocation, or is this just?
This is
the-
just this.
Just this?
Just this. We're not finished. Any discussion on Mr. Commissioner Northern's motion?
Yes.
Okay, what is it?
Unless you're gonna take it up later on.
I am.
Huh?
I am.
The court cost.
Right.
When he gets number 4.
Something else I had. Go ahead.
Any other discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries unanimously. Mr. Northern, you have anything else?
With regards to failure to respond in a timely manner, I move that the respondent be assessed the cost of these proceedings and an additional penalty of $1,000.
For failure to respond in a timely manner, AKA 10 days, I'm going to just sort of paraphrase your motion, that you are making a motion that on that matter, that he have the cost of these proceedings charged to him, which is probably $800 to $1,000, plus a fine of
$1,000.
$1,000
For that infraction.
for that infraction. The cost of these proceedings plus $1,000 for failure to respond in a timely manner. Any discussion on, who made that second? Who seconded that motion?
It
I'll
does not-
second it.
Second, Commissioner Haynes seconds that motion. Any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion passes unanimously.
With regards to our practice of requiring attendance, I'll yield and let commissioners decide on how they want to deal with that.
I want to make a motion. My motion is that he be put on, and we have a payment plan, that you be put on a payment plan that you get with staff, and you work out your payment plan. That you also come back and you attend a 2-day class at this commission. And once you go on that payment plan and you miss them payments, miss those payments, that your license be revoked. And give him the opportunity to pay at his discretion. But if that payment is $10, $200, or $300, and you don't pay, there's a
It would be up
payment
to the
plan there.
commission to determine what the payment plan was.
Pardon?
It would be up to you to determine what the payment plan,
yeah.
Well,
terms of it. We would not be,
how much, what is the,
We've got 1,500 plus 1,000 is 2,500 plus probably another $800 or $900. So we're talking about somewhere around $3,500.
excuse me, for just clarification, I think the court costs will be more expensive than that.
Because
It
they
will
had to
be.
come here.
Okay, so we're up to, I mean, we know we got 2,500 plus court
all right, you
costs.
got $4,000.
Say 4,000. That'd be about $1,500 court cost, roughly. We don't know.
You pay $100 a month?
I think that's not enough.
Do you think that's enough? I
No,
think, huh?
That'll take almost 4 years to
That's
pay
better
out.
than not getting it. And he's, and he, if he don't, he's gonna, if you vote for my motion, he's gonna have his license revoked.
'Cause if
When he misses that payment plan and he doesn't pay, we're gonna revoke his license.
okay.
That's my
Your-
motion.
Your motion is to make,
The payment, set him up on a payment plan, he's gonna pay $100 a month. He misses that payment, misses that first payment, his license is revoked.
you've heard the motion, that Mr. Bond, whatever that figure is going to be set up payments of $100 a month until paid in full. And late, how much? How long?
First payment, he's gonna start paying it.
I know, but I'm saying if he's 15
How
days
many
late.
days late?
15 days late,
If
10
you-
days,
if you-
10 days late.
If you're 10 days late on a payment, that the revocation will be in effect. I
Yeah.
think we can do that.
Are you sure we can do that?
I don't know if we can or not. I don't know if it's in our jurisdiction to do that.
Right, I'd like
I
to hear
don't know.
I'd like to hear from
Either.
state's counsel on that.
They can certainly, yes, we actually have a provision right now with all the agencies, although we don't give them a grace period, that if they miss a payment period, the license, it is the policy of the government that the license is automatically revoked, but without a grace period, but that is certainly up to
Okay.
you.
Well, we didn't know that, but let's forget our grace period.
All right, well,
And
we'll-
and the
we'll-
state specifies the
okay,
days
then
of the
we'll
month that the payments are
disregard
due.
Disregard the grace period.
No grace period.
So
The
we-
state sets the date.
When their consent order is filed, there is a paragraph saying when payments are due, and that if a date is missed, the license is automatically revoked.
Okay. All right, my motion then is that I'll take the revoked out, all he does, if he misses the payment, still $100 a month, then
Automatic revocation occurs at that day.
And
that's right.
Are you going to include in your motion the day, the date, the payments are due?
First of the month,
Well,
10th of the month.
when, he's got to sign the consent order.
It's not a consent
It's
order.
not,
It's not a consent order.
No, this is not a consent order, this is
Right,
final
this
action.
That-
All right, when will it all go down?
Are you asking how long will it take me to get it prepared?
Yeah,
Well, some of it will depend on when I get costs from the two parties here. I expect
okay,
that.
30 days from the date everything is prepared.
Well, I would prefer you put a date certain on the day in there so that we
right.
can.
What about
follow it
June
up.
15? Does that
got-
give you enough time?
June 15th,
That's way more than enough time. I'll have it filed next week.
Okay, June 1st?
today's the 15th.
June 1st?
Are you
When?
saying June 1st and then subsequent the 1st of every month thereafter?
Yes, I like that wordage. You have heard the motion made by Commissioner Alexander. Do I have a second?
Second.
Second by Commissioner Haynes.
That was Commissioner Norwood.
Well,
Either one.
Ms. Haynes, Commissioner Haynes beat him to it.
I was just quiet.
She was quiet over
She's
here.
got to learn to speak in that
I know.
microphone.
And any discussion on this motion? Hearing none, all in favor say aye.
Aye.
Opposed, no.
I
No.
asked for clarification, if you don't mind, that was one no, I'm sorry. A clarification, the date he has to.
I can't hear you, ma'am.
The clarification for when he has to attend the two-day meeting, that's part of your motion?
Within 180 days, like we normally do.
Okay. Thank you.
That's standard procedure.
That was part of his motion.
just-
Within 100,
Right.
within 180
But
days.
it needs to be a part of your order.
Yes.
All right.
Within
Within
180
180 days then.
Okay. Does anybody have anything else to add before we develop a policy statement in this matter? If not, then is someone prepared to read into the record a policy statement in this matter based on the evidence we've heard, the laws that we've determined have been violated, and the appropriate penalty taken? Is there anyone ready to enter read into the record a policy statement in this matter?
Mr. Chairman,
Commissioner Northern.
with regards to policy statement, I would say that it is the duty of this commission to protect the public with regards to the actions of its licensees and to police the industry with regards to the rules imposed by the regulatory body, which is the Tennessee Real Estate Commission. And in this instance, we found that Mr. Bond has in fact violated rules pertaining to the real estate, the regulatory acts pertaining to the Real Estate Commission. And as such, this body found it necessary to impose penalties as previously stated, in hopes that it would deter other individuals from doing the same thing.
You've heard the policy statement that has been read into the record by Commissioner Northern. Do I hear a second to his policy statement?
Second.
Second by Commissioner Haynes. Any discussion on the policy statement that Commissioner Northern has put forth? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Is there any other?
Well, I just have a question. Okay, he's already tested for and passed the broker's exam. So when he applies for that broker's license next week, what then?
Staff?
That's up to you. That's your decision.
So the state wants him to decide
Yeah,
that?
they would have to decide at this point, I think, because the whole
All right,
reason for the
Could he go back through and then mark yes, now that he knows about it?
You'll have to ask your executive director.
She's right here.
Could he go, if he wanted to apply for a broker's license, could he retest, go back through and say, yes, I have a complaint filed against me, and then what would be?
Well, then he'd have to come before the commission to get our
Then he'd have to
blessing.
come before us, and then we would have to say, maybe he would have got some clarification on this other document.
Right, so he could do that, and we do have some people who, we have people who we have individuals from time to time who, as they, like, once they see the answers here, they say, oh, wait a minute, I had a DUI or,
Yeah.
something, and so then what we have them do is we either send them back the original, have them cross it out and put yes and initial it, or we'll have them write basically an affidavit that says, I answered that incorrectly, and it should have been, yes or no, or whatever the situation should have been.
In this
And-
case, I think an affidavit would be more appropriate.
Right, I think so too. I mean, as I say, most of the time, it's really just someone who has
So he's already passed his
he's already passed
test.
his, and he's in
So
fact turned his application in.
Then he could say, I answered it in view of the facts that have been presented, I answered it incorrectly, and here's my affidavit. And then that would have to come back before us, and then we would have to decide if we were gonna allow him to have a broker's license or not.
That's correct. I mean, would be the procedure we would normally follow in a situation.
So that is in effect right now.
Right, and I actually have his
So we don't have to take
application.
any action for that. That would happen if we closed our meeting right now?
I have his
No, I mean, I'm
application.
not saying that that's the way we
No,
want
no,
to do it.
no,
I'm
no,
saying
no,
that's the
my-
way it stands right
I think
now.
though that Ms. Maxwell, at this point, or staff would make that judgment call. My motion, Mr. Chairman, I have a motion that if if Mr. Bond, Adrian A. Bond, applies for a broker's license, before that license be approved, that it be brought before this commission and it be voted on.
Well, that would be in our June meeting. I would
He may not
assume.
apply
He may
anytime
not.
until,
He may change, never do it.
if he may never apply, if he applies 4 years from now or 10 years from now, before he's approved, he comes back before the sitting commission.
I'll second that.
Pardon?
I'll second your motion.
We have a motion on the floor from Commissioner
Just
Alexander.
to be clear then, he's currently licensed as an affiliate in a company that's no longer licensed. So he's either gonna have to get a broker for that firm, or he's gonna have to move his license.
Yes, sir.
If he remains an affiliate.
That's right.
Correct.
That's right.
Understand that?
And I certainly would not have spoke on behalf of this if I had a thought he was gonna apply for a broker's license and run a company at this point.
And to be honest, I wasn't.
And you know, the,
Yeah, but you,
but my motion is, if you understand it, that if he ever applies for a broker's license, that he has to come back before the sitting commission, whether it be 10 years from now. You just flag the file, or 20, anytime in his lifetime. If he applies for a broker's license, he must come back before the commission.
You have heard Commissioner Alexander's motion, which is if Mr. Bond, if and when in the future ever applies to get his broker's license, he will have to come back before the commission to get approved. With his file will be flagged to that effect. Any do I hear a second to this motion?
I'll second.
Second. Commissioner DeShaw, second the motion.
My one
Discussion.
Does he have to resit for the test? Because he's already passed the test?
How long is that test good for?
Well, the test itself, once he files the application, it's good for, you have to file an application within 6 months of passing the test, which he has done.
Yeah.
He's passed both. I mean, I have his application right here.
But it's for the broker, not for.
For the broker, correct. I mean, so I have his
He's
broker's
already
application.
passed the affiliate.
He's already passed.
He's passed the
broker's
broker's
test.
test.
I understand.
I'm talking about the broker's test, so
Right.
he won't have to reset for the broker's test, but he will have to come back before this commission if he wants to obtain that broker's license. I'm just trying to clarify.
Well, you have to file an application within 6 months of passing the test. Now,
Okay.
normally the applications, don't go on in perpetuity. I mean,
Okay,
they
so
last for a
the
year.
test he just passed, he has to file it was in 12.
Which he has done, so he filed the application within, a timely fashion, because he
Right.
passed the test on 2/22 of 12,
Okay.
and then the application we received on April the 5th of 12, so he got within that time frame, and because of these issues, the license didn't issue.
Right.
So now he has so if you go back to the time because it was held up because of
Right.
the actions that we're pursuing, then he could correct this one, or if this expires, if this expires completely, then he would have to retest.
Okay.
But when does that expire
Well,
completely?
they normally are 12 months, but what I mean is because we held this one up
Because we held it up, has he got then 12 months to?
to reapply, to revive this one, as it were.
I'm
Okay.
a little bit confused, because that's a broker
too.
application. I mean, the broker track one. He's
Correct.
still an affiliate broker, whether he follows through on that or not.
That is correct, yeah, I just meant he has currently passed the test
Well, Michelle's-
for broker already.
I'm just talking about his
Trying to find out
brokers.
is
Oh.
if he's gonna have to retest
If
again.
he's
That's what
gonna
she-
have to,
Okay.
we say he's gonna have to come back before us, period. But if he wants to use this broker's test, he's got 12 months then to come back before us. So this stands, his broker's test stands for the additional 12 months. Is that what I'm understanding? I mean, I just want to clarify.
Right,
There have been
it's,
so
and
many
as
things
I
that
say,
weren't
it's in
clear.
part because he already turned the application in,
Okay.
in a timely fashion, and then it was held up, it was held up because it was our, it was
So-
because we filed the complaint, it was
He
held
gets
up.
all this figured out, and he comes back and says, this is what happened, and da-da-da-da-da. but he's got 12 months on this particular test to come back if that's what he wants to do.
I don't believe he'll be back in 12 months.
I don't believe he will either, but I just want to clarify it.
But if he does, he would come before you all regardless. Whether
Regardless.
it's 30 days
Okay.
or 60 or
Okay.
90. Is that what you all, is that what the commission
That's
decided?
what, yeah. Now, I'm just looking for clarity.
Okay.
I
Well,
would.
is it 12 months from the day he applied, or 12
be
months
12
from the
months
day
from
he
today
passed the test?
is the way I
Or 12
get
months
it.
from today?
I would say
You
12
might need
months
to
from
specify
today.
that.
Right, it's 12 months from the test, except that, I mean, but we held this one up. You know, like it was our,
Right.
So because we
Right.
held it up,
So it'd be-
I would say 12 months. Should I make should I?
yeah, I think
do
you should
that?
make a
need a
motion,
motion. We
right.
need a
I would-
Just include this friendly amendment to Mr.
A friendly
Alexander's
amendment
motion.
that his test, he's got 12 months from today, if he wants to use the broker's test that he did pass, to file for a broker's license, if he so chooses. If not, after that, he will have to retest. So it'd be 12 months from this day.
You have, you have
Is that,
a problem
I mean,
that being part of your motion, Mr. Commissioner
No,
Alexander?
No, I tell you what, I will accept the friendly amendment too.
Okay.
Is-
What will you accept?
Is that it'd be 12 months or his pay plan is paid in full.
okay.
Okay. Heard that motion.
He's 12 months and and that he's paid his payment plan in full. In other words, you can come back in 12 months, provided you paid your fine and
Provided you pay your fine.
in
Okay.
full.
So it's 12 months and?
Pardon?
It's 12 months and?
And/or.
And/or, okay.
He's gotta do both of them.
And/or when you write it, would be provided he has paid his payment in full, not and/or.
So it's 12 months from today,
He would have had to have already made his
But he-
payment in full
okay.
to come back.
Okay.
On the current broker's test.
And paid his fine in
And
full.
he would have had to have paid his fine in full.
Okay.
And come before the
Penalty.
commission.
Penalty, sorry. Keep us straight.
Okay, you've heard the motion with this friendly amendment added to it.
Call for the question.
Any discussion? Hearing none, the question has been called. All in favor say aye.
Aye.
Opposed, no. Motion carries. Does this conclude the matter of Adrian A. Bond, docket number 1218-120574A?
Just so I'm clear, Ms. Ryan, does this need to be put in the form of a consent order or an agreed citation?
This is not an agreement, this is a hearing.
Formal
I
hearing.
understand,
There's no consent involved.
okay, so it's a final order.
If that's what the judge says.
This is just like Judge Judy. All rulings are final. Is there, I think this concludes, I'm turning it back to you, Judge Williams.
No, this concludes the hearing.
The hearing is concluded, and
Mr. Chairman, it's closed. Now, Mr. Bond, you've got some other issues that you need to get worked out about you getting transferred and these things out of the company. And you might need to talk to staff of what's gonna happen there. If you don't, they're gonna may file another complaint against you. Okay? All right, that's all I had to
is
say.
there anything else to come before this commission meeting?
Yes, just a short clarification, and I'm glad the judge is here to do it. You asked me earlier, when we were talking about having matters heard before an ALJ alone, and I told you that if you didn't, it could then be, it's an initial order, and then it was reviewed by the commission, and then what happens after that fact. And I have found the review for initial orders are, the commission can review the initial order and has to, if they want on its own initiative to review it, that means do something different than what's in the order, you shall give written notice of the intention to review the initial order within 15 days after its entry. And then at that point, the petition for appeal shall state its basis for the basis. And if the agency on its own motion gives its notice of its intent to review initial order, the agency shall identify the issues that it intends to review and the agency shall afford an opportunity to present briefs and may afford each proper party an opportunity to present oral argument. Summation of what that is, and this is what we're clarifying, Judge, just so you know, is that if an administrative law judge issues an order that you want to review and you are not in agreement with, you have the power to do that
Within 15 days.
Within
after
15
the
days.
review. Mhm.
So what happens if they do
You,
something?
the petition shall be filed with the agency within 15 days, okay? And you have to, you give the written notice of your intent within 15 days.
But we only meet every 30 days.
You give a written notice of your intent within 15 days. It doesn't mean that the hearing has to be within 15 days or that the briefs have to be done in 15 days. It means that after reviewing the order, when it's presented to you, you have to make a decision
Oh,
within the 15
okay,
days.
so you present it to us at a meeting, and we need to decide at the meeting if we're gonna.
That's how I would
Gotcha.
interpret that, after
Okay.
the initial order is presented. Or a special meeting would be called.
Okay.
I move we adjourn.
Any other matters to
I'll
come
second
before
that.
this meeting before I recognize Commissioner
Sorry.
Alexander for his motion
Sorry,
to
sorry,
adjourn?
stop.
Judge Williams.
Just a second. The initial order is issued by the administrative judge, and it comes to the agency.
Right.
It becomes a final order within 15 days if there's no petition for reconsideration or
Right.
review.
Well, that's why I was saying we may have to call a special meeting for them to reconsider it, but they would still be able to review it. What?
Can it be an electronic voting?
Like, could we do it by email or by phone conference? Or
I believe so.
Yeah, you can meet as the commission by telephone conference,
Right,
as
we-
long as you make opportunities available for the public to join in as well.
Yeah,
Oh.
we
That's gonna be hard, yeah.
have done that before.
Yeah.
The issue, Your Honor, is that the commission is deciding to allow certain things to be heard by an ALJ alone, and they wanted to be sure they could review it and what their parameters of the review was.
Right, and that's where the 15 days
Right.
comes in.
Right.
And do we do that 15 days on errors and omission? Because I don't
No.
think we did it that way.
In errors and omissions insurance, the initial order is presented to you, and the only issue on any of it is if you decide not to go with what it is. It becomes a final order, as the judge says. So if there's no objection by the
Right.
commission, then it becomes a final order.
That's right.
Okay, okay.
Any other matters to come before this commission meeting? Judge Williams, are you finished with your
Yes.
part? We appreciate our court report. Hopefully, we haven't been too difficult for you to transcribe everything, but we appreciate you being here. Motion has been made to adjourn, it's been seconded, and we are adjourned.
All right, you probably want to mark this.